Good morning. Are you Judson Bell?
Yes, ma'am.
And Mr. Bell, in cause number 25 DCCR 0108, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that is from January 20th of 2024. Your indictment alleges you were previously convicted of possession of a controlled substance and delivery of a controlled substance, a third degree and a second degree, October 22nd of 2007. And after those were final, you were convicted of unlawful possession of a controlled substance, a second degree, February 4th of 2009. And what that means is if you go to trial in that case and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And then in clause number 25 DCCR 0109, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from January 20th of 2024. That indictment alleges those same prior offenses, which again means if you're found guilty and those prior offenses are true, the range of punishment would be that of a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0110, you're charged with the second-degree felony offense of possession of a controlled substance from January 20th of 2024. The indictment here alleges those same prior offenses, again meaning that if you go to trial and you're found guilty, the range of punishment would be a minimum 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the computer in each of those cases plea bargain rejections that you've signed with Mr. West that shows that the district attorney's office has offered, if you wanted to enter a plea of guilty, a 25-year term in the institutional division. You have every right to reject that and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. You understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
Mr. Nichols, is there any reason in Mr. Smith's file, any notation why this would be?
No, Your Honor, he has the priors that were listed plus a federal prior, which is, I think, still under their supervised release and he's on parole through 2027. I see no reason he would change.
So I want to make sure you understand, Mr. Bell, that after today, I will not accept this plea agreement. Unless there is anything new that comes up, I will not accept a plea agreement less than this. So it's trial, plea open to a jury, plea open to the court, or something different. I want to make sure you know that just getting on the trial docket doesn't mean you're going to get a better deal later. Do you understand?
Yes, ma'am.
And you want to reject those offers and have all of your cases set for trial. Is that correct?
Yes, ma'am.
All right, we'll get them set for trial. Mr. West will begin preparation for trial. You can go back with the bailiff. Good morning. Are you Chad Smith?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
We will, Your Honor.
Mr. Smith, in cause number 24, DCCR 2309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 6 years. You would be ordered to pay $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond based on that plea?
Judge, I'm not necessarily opposed to a bond due to the nature of the underlying offense. Would advise the court that he does have a prior state jail from last 2 years ago for a drug possession case out of Brazoria County. And it also looks like there have been some misdemeanor priors as well, but I would defer to whatever you think is appropriate.
Where will you live when you're released, Mr. Smith?
I'll be living with my sister and her husband in Lumberton.
In Lumberton?
Yeah, I've been sober for 1.5 years now. I've been got my CDL, but I have a life waiting for me. I've
Good.
been on the right path. I just needed to take care of this.
Sure. So what I'm going to do, Mr. Smith, is reduce your bond to $1,000. I'm going to make that a personal bond, which means you're just going to be released without having to pay any money.
Okay.
But there's a few things that are very important about that.
Okay.
If you don't show up for court when you're supposed to, then they're going to come after you for the money,
Yeah, of
number
course,
one.
of course.
Also, the first thing you do when you're released today, if it's early enough in the day, is go straight to probation. You're going to get some paperwork today. They'll tell you where to go so they can start that process to do that pre-sentence report.
Okay.
If it's late in the day, go first thing in the morning.
I'm sorry. I didn't mean-
Right out of the gate, this judge isn't sugarcoating anything she's telling Judson Bell. He could face up to life in prison because of his repeat offenses. When you hear habitual offender, that's legal code for you've done this too many times for mercy to apply.
So if you don't do that, then you run the risk of me not accepting the agreement and things could be worse. If you're arrested for anything between now and when we come back for sentencing, also you run the risk of me not accepting the agreement. And did you have a question?
I was just going to say that'll all state like which I'll be in Beaumont for the probation.
Just, if you're living in Lumberton, talk to the, when you're doing that pre-sentence investigation, talk to the probation officer about where you'll be, and they'll start the paperwork to see about courtesy supervision where you are.
So just depending on when they let me go today, whether I go today or in the morning?
Yes, sir.
Okay.
Yep, if it's before 5, then get over there straight today.
All right.
Okay? And you're going to get some paperwork to tell you all that.
Judge, I'll send a dismissal on that misdemeanor so that doesn't hold him up.
Okay, thank you. All right. Yes, sir. Good morning. Are you Christopher East? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. East, in cause number 24, DCCR 1742, you're charged with evading arrest or detention with previous convictions from July 17th of 2024. The indictment alleges you were previously convicted of evading arrest or detention August 21st of 2015. And how do you plead to that charge?
No contest.
Either you did it or you didn't do it. It's guilty or not guilty.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with? I'm sorry?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. East is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous conviction. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It looks like the state is going to dismiss cause number 24, CCCR 2313 as part of this agreement as well. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you George Celeststeine Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Celeststeine, in cause number 24 DCCR 0746, you're charged with the state jail felony offense of evading arrest or detention with previous conviction, and that's from March 4th of 2024. The indictment alleges you were previously convicted of evading arrest or detention November 28th of 2012 in Hardin County, Texas. And how do you plead to that charge? And is that prior conviction true? Are you entering your plea of guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Celeststeine's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest or detention with that previous conviction. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right? Good luck to you, sir. You can go back with the bailiff.
Hold up, he just rejected a 25-year plea deal most people would grab that to avoid a possible life sentence. Do you think he's confident in his innocence, or just rolling the dice? Comment below. Would you ever risk trial time like that?
Good morning. You're Haven Jenkins?
Yes, ma'am.
And Mr. Jenkins is charged in 24 DCCR 1026 with aggravated robbery and 24 DCCR 1027 with fraudulent use or possession of identifying information. What is the announcement?
Judge, he's previously rejected 10 on the aggravated robbery case and 5 on the possession of fraudulent identifying information. That offer has not changed. I visited with him. I've looked at the file. There are co-defendants in the aggravated robbery case, and I think during trial preparation there may be mitigating or exculpatory evidence that would come out, and therefore he is requesting a trial.
Okay.
However, Judge, this case originated out of Groves, Texas. I've got a conflict with going to trial with the Groves police, so I'm going to have to ask that I be replaced on this case. If you want me to file a motion, I can.
No, didn't realize that. Mr. Nichols?
I don't have an objection to his withdrawal, Your Honor. I understand the conflict, and as far as the offer and everything, I know Mr. Smith has been over it several times, and I don't see why it would change, Your Honor.
So, Mr. Jenkins, because of, you probably already talked to him about that, I'm not sure, but he's not going to be able to represent you just because of where this happened or allegedly happened. And so what I'm going to do is release Mr. Reynolds today. I'm going to appoint an attorney today. We're going to contact them personally, let them know that you're ready to go forward with trial, that someone else has looked at at it. Mr. Reynolds, if you will make sure and get everything you've received once we get that new attorney to them as far as discovery goes. If there's any media, especially, obviously the discovery portal stuff they can get. But if you've received any media, then if you'll get that to that attorney, and then they'll be out there very soon, and we'll have one more court date with that attorney, and then we'll get it moved to the trial docket.
Yes, ma'am.
Okay, you can go back with the bailiff. All right, are you Victoria Bailey?
Yes, ma'am.
And Ms. Bailey is in 25 DCCR 0170 charged with assault on a public servant, and in 25 DCCR 0278 charged with assault of hospital personnel. And Ms. Bailey was evaluated for competency to stand trial by Dr. Capon. I received that report dated April 22nd of 2025. Dr. Capon makes the finding in each of these cases that Ms. Bailey is currently not competent to stand trial, and that inpatient treatment for competency restoration is warranted. Is there any other evidence with regard to competency, Mr. Parker?
None, Your Honor.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I am going to find Ms. Bailey not competent to stand trial, order that inpatient treatment for competency restoration be provided at the appropriate facility, and that at that facility for a period of not to exceed 120 days from the date Ms. Bailey gets there, and we will await to hear if she has been restored at the end of that 120 days. You can go back with the bailiff, ma'am.
120 days?
Well, they're going to send you to a hospital to get you some help to make sure you understand everything better. And so cooperate with everything they want you to do, and we'll get you back here and get your cases taken care of, okay?
So I'm going to the hospital, then back to jail?
Yes, ma'am.
120 days at the hospital?
Well, it depends if you do what they say at the hospital and follow all the instructions, medication, whatever it is, so that you have a better understanding of everything that's going on. Okay?
I don't need medicine to understand.
You can go back with the bailiff. Good morning, sir. You're Calvin Lee Randall. And Mr. Randall, in cause number 24 DCCR 1278, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from May 17th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
That's it. No yelling, no argument, just quiet defiance. The judge's tone says it all. She's done giving deals. Now pay attention, because the next defendant story takes a very different turn.
And then in cause number 24 DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises from May 17th of 2024. If you're found guilty in that case, the range of punishment would also be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 24, DCCR 1530, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. In that case, what that means is if you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And then finally, in cause number 21, okay, so we've got an MTRP.
Yes, sir.
Okay, and that one, you're on probation for aggravated assault causing serious bodily injury. Based on the nature of that underlying offense, Mr. Nichols, what's the state's position with going ahead and setting the, I'd rather go forward on the motion, honestly. Maybe?
I'm looking at Mr. Smith's offers in the case, and that all seems to line up. I don't see why we wouldn't, Your Honor.
Set it for, obviously it would take some time. We could set aside half a day and go forward on the motion. It's just as serious as the others, so just as soon get that taken care of. And then if we still need trials at that point, we can get the rest set for trial. So let's do this. I'd like to go through that motion. On those other three cases, before we move to that motion, I do want to go through real quick. I've got plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. Looks like to 16-year term in the second-degree felony offenses And so it looks like the offer would be to dismiss the evading arrest or detention with the use of a vehicle for pleas on the aggravated assault with a deadly weapon and the unlawful carrying, those second degrees, for 16-year terms in those cases. Do you understand? And do you want to reject those offers and have your cases set for trial? All right. Best you can, raise your right hand for me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. You can put your hand down. Here we go. In cause number 21-36882, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation August 30th of 2021 for the offense of aggravated assault, family violence, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department February 21st, May 25th, June 13th, October 12th, and November 5th of 2023. And is that true or not true?
True.
Not true.
So you reported on those dates?
I had,
I mean, and
I was
hold on.
medicine.
Well, Mr. Smith, I want to make sure, if some of them are true, I mean, if he wants to plead not true to everything, that's fine, but
Well, I was just taking judgment purposes this morning, just believe not true.
no, for purpose, he's under oath, if it's true or it's not true. So if you reported, fine. If you didn't report, fine. We're going to get explanations later.
Okay.
So if what I'm reading out to you is not true, obviously the new offenses we're going to have a hearing on. But these administrative violations, if you didn't report, you didn't report. If you did, you did. All right? So on those dates, is it true or not true that you failed to report?
This is a rare moment of compassion in a Texas courtroom. The judge sees someone who's actually trying sober, working, rebuilding life, and she rewards it with a personal bond that's basically a free release, but only if he walks the straight line from here on out.
Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample July 3rd of 2023 that tested positive for tetrahydrocannabinol and methamphetamines. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the BIP or an anger management program. Is that true or not true? I'm sorry?
True.
Count 6 alleges that you're behind in your court-assessed fees as of December 5th of 2023 in the amount of $3,192. And is that true or not true?
True.
Count 7 alleges that you committed the new offense of aggravated assault with a deadly weapon May 17th of 2024. And is that true or not true?
Not true.
Count 8 alleges that you committed the new offense of unlawful carrying a weapon on alcohol premises May 17th of 2024. And is that true or not true?
Not true.
Count 9 alleges that you committed the offense of evading arrest or detention with the use of a vehicle May 17th of 2024. And is that true or not true?
Not true.
All right, so I'm going to, did you enter your pleas of true to counts 1 through 6 freely and voluntarily? The counts that you pled true to, 1 through 6, did you do that freely and voluntarily? And because those are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not doing that today. I'm going to reset the case for a hearing so that the state can, those are all from the same date.
Yes, Your Honor.
Correct.
I should be able to prove them up.
And so we will set this on a date when we're not in trial so that we have a few hours for that, and then we'll see where we get after that and get the other cases set for trial if we need to. All right? You can go back with the bailiff. And I do want an updated report, please.
So far, we've seen everything from life-threatening sentences to second chances. But up next, the judge faces a case where mental health completely changes the legal outcome. Watch how differently the system reacts when competence becomes the issue.
Good morning, sir. You're Brandon Dodd.
Yes, ma'am.
And Mr. Dodd is charged with the offense of murder in cause number 24 DCCR 2418. Mr. Burbank, what is the announcement?
I just need one more setting. I was just hired with Mr. Dodd. I talked to him last week. There's some information that I need in order to be ready at the next time.
Sure.
I'll be able to announce I'll be up to speed with Mr. Coleman and my client.
Okay. All right, so we'll just do one more reset, Mr. Dodd. That way Mr. Burbank can get up to speed on everything, go over everything that he's received evidence-wise with you, and we'll get an announcement at that next court date.
Here's something many people don't realize. Being not competent to stand trial doesn't mean you're innocent. It means you're not mentally capable of understanding what's happening. The goal is to restore that competence before trial, not to set you free, fair, or flawed system. Let's talk in the comments.